5 seconds to go. Start. This amendment will take effect from 1st April 2014 and will accordingly apply in relation to the assessment year 2014-15 and subsequent assessment years. With regard to gallonage fees, license fee and the shop rental, it is submitted that High Court has upheld the disallowance in favour of the revenue with regard to FL9 license on the ground that the appellant KSBC is the exclusive license holder so far as FL9 licenses are concerned. It is submitted that so far as FL1 licenses are concerned, only on the ground that similar licenses are also given for another license holder which to Kerala State Cooperative Consumers Federation Limited, the High Court has held that there is no exclusivity so far as FL1 licenses are concerned. It is the contention of the learned counsel that the disallowance under section 40A2B is not contingent upon the nature of license. The test should be whether levy under the Abkari Act is exclusive or not, and in this case it is exclusive. It is submitted that the restricted interpretation made by the High Court to the extent of FL1 licenses issued in favour of the appellant runs contrary to object and intent of section 48(2)(b) of the Act and makes the said provision redundant and otiose. It is the case of the revenue that the aspect of exclusivity used under section 48(2)(b) of the Act has to be viewed from the nature of undertaking on which levy is imposed and not on the number of undertakings on which levy is imposed. It is further submitted that the KSBC and the Kerala State Cooperatives Consumers Federation Limited are undertakings of the state of Kerala. Therefore, the levy is an exclusive levy on such state government undertakings which are licenses. So far as surcharge on sales tax is concerned, again it is submitted that such a levy is an exclusive levy on KSBC alone, therefore attracts section 48(2)(b)(a) itself. Alternatively, it is further submitted that even assuming that such tax is not attracted by section 48(2)(b)(a), it would fall under section 48(2)(b)(b) for the reason that surcharge on sales tax is a tax and tax is a form of appropriation by the state from KSBC. It is submitted that the surcharge levied under section 3(1) of the KST Act is on the tax payable by a dealer in foreign liquor under section 5(1) of the KGST Act. It is the contention of the learned counsel that the cumulative reading of section 3(1) of the KST Act and section 5(1)(b) of the KGST Act would reveal that surcharge is levied on the tax payable by a dealer in foreign liquor under section 5(1) of KGST Act. It is submitted that section 3(1) does not deal with any other category and specifically pertain only to a dealer in foreign liquor. It is submitted that as much as section 5(1)(b) of the KGST Act refers to trade in foreign liquor and it applies specifically and exclusively to KSBC, and further surcharge levied under section 3(1) of KST Act is on the sales tax exclusively payable by KSBC under section 5(1)(b) of KGST Act. As such, the inevitable conclusion therefore is that it qualifies as an exclusive levy attracting section 48(2)(b) of the Act. To show that the distinction between a tax and a fee has substantially been effaced In the development of constitutional jurisprudence, learned counsel has placed reliance on a recent judgment of this court or a charge. Therefore, High Court was of the view that surcharge levied on KSBC does not attract section 40A2B of the Act. The submission of Shri Venkataraman, learned ASG, with regard to surcharge on sales tax is twofold. One is that the levy of surcharge on sales tax is also an exclusive levy on KSBC, therefore attracts section 48(2)(b)(a) itself. Secondly, it is submitted as an alternative submission that if the same is not covered by section 40(a)(2)(b)(a), it would fall under section 48(2)(b)(b) of the Act for the reason that the surcharge on sales tax is a tax and tax is a form of appropriation by the state from KSBC. Stop.